Perhaps the most personally upsetting part of the story is the lengths to which the leadership of the department has gone to prevent me from testifying here. Oh, it's just reading her.
Perhaps the most personally upsetting part of the story is the lengths to which the leadership of the department has gone to prevent me from testifying here today. On Friday night, around 9:15, I learned that the Deputy Attorney General's office had directed the Department's Security and Emergency Planning Service to send 2 armed Special Deputy U.S. Marshals to my home to serve me with a letter. The letter was to be served at my home between 9 o'clock and 10 o'clock on Friday night. I was in the car with my husband and my parents, who are sitting behind me today, when I got the news that the officers were on their way to my house where my teenage child was home alone. Fortunately, due to the grace of a very decent person who understood how upsetting this would be to my family, I was able to confirm receipt of the letter to an email address, and the deputies were called off. The letter had been emailed to me just before 8 o'clock that night. At no point did Mr. Blanche's staff pick up the phone and call me before they sent armed deputies to my home. The letter was a warning to me about the risks of testifying here today. But I am here because I will not be bullied into concealing the ongoing corruption and abuse of power at the Department of Justice. DOJ is entrusted with keeping us safe, upholding the rule of law, and protecting our civil rights. It is not a personal favor bank for the president. Its career employees are not the president's personal debt collectors. I see only Democratic members here today, but this is not a partisan issue. It should alarm all Americans that the leadership of the Department of Justice appears to value political loyalty above the fair and responsible administration of justice. It should offend all Americans that our leaders are treating public servants with a lack of basic decency and humanity. Thank you.
What were they trying to... What is this in relation to? They sent the Marshals to her house, not deputies, to prevent me from testifying here today. To prevent her from testifying? Is that... I don't even know what this testimony was about. Justice Department... okay, U.S. Marshals... Oh, Jesus. U.S. Marshals were mobilized to warn fired DOJ attorney over congressional testimony, attorney says. The U.S. Justice Department dispatched armed U.S. Marshals to deliver a letter warning a fired career-pardoned attorney about testifying to congressional Democrats, her lawyer said in a letter seen by Reuters on Monday. This highly unusual step of directing armed law enforcement officers to the home of a former Department of Justice employee who has engaged in no misconduct, let alone criminal conduct, simply to deliver a letter is both unprecedented and completely inappropriate. The Marshals were called off on Friday only after Oyer acknowledged receiving the letter once she located it in a secondary email that she had not been using to communicate with the department's human resource officials. While U.S. Marshal deputies are sometimes used to serve congressional subpoenas or protect witnesses, dispatching them to deliver a letter from the DOJ is unusual. Oyer, who served as the pardon attorney during President Joe Biden's tenure, was one of several career officials fired by Deputy AG Todd Blanche on March 7th. Oyer since told U.S. media outlets that her firing came shortly after she declined to recommend restoring gun rights to actor Mel Gibson, a supporter of President Donald Trump. She was one of several Justice Department officials who testified on Monday afternoon after hearing... Wait, what? He's a felon.
Oh, this is gonna be spicy.
What do you mean?
This guy went full MAGA. A long time ago, but I don't know where he's at now. I wonder what his take is on this.
What do you mean? What do you mean?
Mel Gibson just had his gun rights restored by the Department of Justice under General Pam Bondi. And as expected, people feel some type of way about it.
Restoring Mel Gibson's gun rights sparks legal saga over his connection to President Donald Trump. The Department of Justice, under Attorney General Pam Bondi, approved Gibson's request alongside 9 other cases. The decision fueled a dramatic internal conflict at the DOJ, leading to the dismissal of U.S. Pardon Attorney Elizabeth G. Oyer, after she resisted pressure to approve the case based on Gibson's political connections. Oyer, later voicing her strong disapproval in an op-ed for Rolling Stone, warned that restoring gun rights to individuals with histories of domestic abuse could have dire consequences. The entire episode has sparked a fierce debate, with critics warning of a dangerous precedent where political influences...
Were his gun rights restored just because he requested it and like the Trump admin approved it, or is there something more going on here? Was it literally just that?
overshadow legal prudence, while supporters argue it is a rightful restoration of Second Amendment privileges to those who have already served their penalties.
You see, the DOJ restored rights to 10 individuals, but Mel Gibson is the one that everyone's talking about. And to add more fuel to the fire, reports say that the DOJ's former pardon attorney opposed the decision. And then not long after, she was let go. Now, just to be clear, we don't know for sure she was fired because she pushed back against the Mel Gibson decision. That's part's not really confirmed, but it's out there and it's being talked about.
Now the attorney who says she was fired by the Department of Justice after opposing actor Mel Gibson getting his gun back.
An attorney for the U.S. Justice Department, Liz Oyer, says she was fired a day after refusing to restore Mel Gibson's gun ownership rights. She tells the New York Times she knew her government job was over and confided to a colleague, "I can't believe this, but I really think Mel Gibson is going to be my downfall."
Personally, I would like to see the list of people she had. And if any of them had anything close to the same conviction as Mel Gibson, then you could argue she's full of shit. Now, if none of the 10 people on that list had anything close to Mel Gibson's conviction, then you could possibly argue that her termination was retaliatory. But I think there was way more to this than just being fired because she wouldn't pardon Mel Gibson. Now, before I really dig into this, let me just say this. Am I a Mel Gibson fan? Yeah, I'm a fan of Mel Gibson, the actor. The man gave us Braveheart, The Patriot, and Apocalypto. He knows how to move an audience. Am I a fan of Mel Gibson, the person? Not really. But I've never met him. But considering he's on record saying this,
"You look like a honey, and if you get raped by a pack, it's your fault."
I'm not exactly running to his defense. And it's not just that he said it, it's how calculated and venomous it was. I'm not a sensitive guy by any stretch of imagination, but that was comically unnecessary. I have friends of all races, and we all say the most racist shit to each other. But our racism is an expression of love. Yeah, I know that makes no sense, but guys are weird.
Wow, super epic.
The way Mel Gibson said it was antagonistic and vitriolic. So yeah, if I had to describe my feelings towards Mel Gibson as a person in one word, that word would be apathy. Things like that don't bother me on a deep level because I really don't care enough about idiotic childish slurs to let it ruin my day. I just live my life and let people live theirs the way they want to. I have better things to focus my energy on. But here's the thing. This is where a lot of people get uncomfortable. My personal feelings don't determine someone else's constitutional rights. That's not how this works. Rights don't bend around my emotions. They're either protected for everyone or they're protected for no one. Back in 2011, Mel Gibson pled no contest to a misdemeanor battery against his ex-girlfriend. That means he didn't admit guilt. He just accepted the punishment without going to trial.
There is more trouble for Oscar winner Mel Gibson this morning. Police in Malibu, California now investigating a reported case of domestic violence involving his ex-girlfriend. CBS News correspondent Bill Whitmer.
Is he going to explain more for what happened, or?
Law enforcement officials say they've opened a preliminary inquiry into claims that Hollywood star Mel Gibson physically abused his former girlfriend, Russian singer Oksana Grigorieva.
We don't know exactly what happened between them and how much of it was kind of in the heat of the moment, but if these statements turn out to be remotely true, I think Mel Gibson has a lot to answer for.
Now, here's the important part. Even though it was a misdemeanor, under federal law, specifically the Lautenberg Amendment, a misdemeanor domestic violence conviction can legally prohibit you from owning or possessing a firearm. So yes, his no contest plea barred him from legally owning a gun. Do I agree with that amendment? No, not really. That's what makes this whole conversation worth having, because it's not about favoritism. It's not about celebrity. It's about what happens when time passes, someone serves their punishment, and then asks to have a constitutional right restored. So the real question becomes, what's the point of rehabilitation if there's no pathway to restoration? And that actually brings me to something I've been using a lot lately, ground news. This Mel Gibson story is a perfect example of why an entire bias favor. Their Chrome extension lets you ground.news/colon to subscribe. Use my link and you'll get 40% off the Vantage subscription, unlocking all these tools. You'll be getting better ways to see the news and you'll be supporting my work directly. That's ground.news/colon. Click the link in the description section and start seeing both sides of the story. Now,
thanks.
I don't exactly trust his ex either. I'm not saying she was lying, but I also wouldn't leave her alone in my condo, much less alone with my heart. I know an apex predator when I see one.
For 7 months, Chris Herzog was Oksana Grigorieva's bodyguard. And according to Herzog, that special friendship grew into an affair.
All I'm saying is, Oksana Grigorieva, however the you say her name, is a gold digger whore. Just like Mel Gibson said. I know how bitches are. I am female. And when it's about money, a bitch can get real scandalous.
All jokes aside, this is about principle. If the state believed what Mel...
Okay, why are we giving, not to sound loyal or whatever bullshit, but like, why are we giving character evidence for this lady to demean her character? And she might actually be a piece of shit, I don't know. But for Mel Gibson, the only thing we had was the actual court pleading and nothing else. That should always make you wonder, like, well, hold on, why are we bringing in this stuff about who the woman was? But for Mel Gibson, all we heard, and we didn't even hear, by the way, what it was about. It was a misdemeanor battery. What's that? I don't know. That could be anything from, like, that could have been pled down from, like, fucking, you know, threatening with a weapon or something. I have no idea. We had no information about that, but then we're getting YouTube videos about the character. Okay, whatever. But all right, interesting. Actually, you know what? No, it's not interesting. You know what? Hold on. Now we're going to read about it. Now I'm curious. Mel Gibson plead misdemeanor. The actor Mel Gibson's years-old misdemeanor conviction on domestic violence charges made headlines again this week after a Trump administration official said she was fired for refusing to recommend that his gun rights be restored. The episode brought up an unusual aspect of American law. Most people convicted on minor charges can keep their guns, but domestic violence charges are different. He lost his right to own guns after his conviction in 2011. Federal law prohibits all those with felony convictions and those with certain domestic violence misdemeanors from possessing guns. Experts say there are clear reasons that the law singles out domestic violence offenses for special treatment. One study found that when abusers had access to guns, their victims were at least 5 times as likely. Does it say what happened exactly? What happened in the Mel Gibson case? On Monday, a Justice Department official said she had been fired. Okay, wait, no, what happened on the actual... In 2011, Mr. Gibson pleaded no contest in Los Angeles Superior Court to a misdemeanor charge of battering his former girlfriend as part of a deal with prosecutors that allowed him to avoid jail time. He received a sentence of community service, counseling, and 3 years of probation and was ordered to pay $570 in fines. This doesn't say fuck all about it. Good one. Okay. Grigorieva? I don't even know. Okay. Accused Gibson of egregious acts, hitting her and their daughter, whom she was holding in her arms, punching her in the mouth and breaking her teeth, and verbally berating her during numerous phone calls. Did he get off easy? Good one. Not necessarily, according to legal experts. It's normal for a defendant to receive a milder punishment with a plea deal than with a trial, and it made sense that Gibson wanted to avoid going to trial. Given her testimony and his, given that he also admitted in a family law filing that he did hit her, though he claimed it was for the protection of the baby, with all of that, at the minimum, he would be convicted for misdemeanor battery, and at the maximum, felony battery, said family law attorney Gloria Allred. What would be the point in undergoing a trial with all the massive coverage if at the end he's going to be convicted? Another factor that likely led to Gibson's purported decision to not go to trial, he has a movie coming out, The Beaver. How confident are we that her teeth got knocked out because of him hitting her? Do we know this? How much is this known? Oh, you linked me to the exact same article I found. Probation for 36 months in order to attend a year of domestic violence counseling. Oh, 16 hours of community service. Wow. TMZ has literal pictures. Check my link. Oksana teeth photo, dental pictures from Oksana the morning after. Yeah, I was going to say this. Do people... I actually have no idea. If you get into a fight or whatever, are you likely to break a tooth? Or would you be more likely to have a tooth just get knocked out? Also, there's no bruising on her face, so maybe she didn't get hit. Who knows? That happened to Sneeko? Veneers were damaged, but her teeth were not fractured. Dr. Sheldon had also said Oksana was not punched in the mouth. Noticing the pictures and evidence of bruising, as he reported, Dr. Sheldon claims Oksana hid the bruising with her hair and makeup. According to the declaration, Dr. Sheldon told Oksana she needed to protect herself. He did not, however, report the alleged attack to authorities. Huh. Okay. All right. Anyway. Okay. We have some more information.
Did was that dangerous. They should have charged him with a felony. They didn't. They gave him a misdemeanor. And unless we're now in the business...
Wait, hold on.
Scandalous.
All jokes aside, this is about principle. If the state believed what Mel did was that dangerous, they should have charged him with a felony. They didn't.
Why do we give commentary on things? We don't even like... It took me like 3 seconds to just Google this case. Like, it sounds like he made a plea deal. It's probably harder to get convictions here. People will often plea out for a variety of reasons. They don't know. Nobody likes a jury trial because who the fuck knows what will happen. It saves resources for the court. It guarantees you a conviction for some level of wrongdoing. Like, why? Like, if they really thought it was bad, they should have, like, whatever. Okay.
If the state believed what Mel did was that dangerous, they should have charged him with a felony. They didn't. They gave him a misdemeanor. And unless we're now in the business of retroactively upgrading charges...
Wait. Hold on. I just realized how fucking weird that dude's name is. Mel? Is that a real name? Is it short for something? For Mel Gibson? I've always heard him referred to as Mel Gibson. Mel. What kind of name is that? I had an uncle twice removed or something called Merle from Kentucky, I think.
With the felony. They didn't. They gave him a misdemeanor. And unless we're now in the business of retroactively upgrading charges because we don't like someone, then the standard has to remain the same. And look, I've said it before. I believe there should be a pathway back to rights, especially for nonviolent felons. And in cases involving violence, evaluate it case by case. Look at the context, the time that's passed, and how the person has lived since.
No shot. This actually happened. Where is the one lawyer dude? The Supreme Court has vacated Boasberg's orders barring Trump's removal under the Alien Enemies Act, largely over venue, but emphasized the administration must give reasonable notice for targets to challenge. So they ended up going with the habeas memes? No actual shot, right? I don't know how you spell habeas. Oh. We grant the application making the TROs. The detainees seek equitable relief against the implementation of the proclamation against removal under the AA. They challenge the government's interpretation of the act and assert they do not fall within the category of removal aliens. We do not reach those arguments. Challenges to removal under the AEA are a statute which largely precludes judicial review. Must be brought in habeas. Can you TLDR it for retards? Not really. There is no TLDR here. It's kind of complicated bullshit. Also, I don't have the, I haven't done enough individual reading or research on how this works, but my layman-ish take is that basically, part of your right to due process is if you get arrested, all right? Let's say that you get arrested, all right? An arrest, okay? An arrest has to happen because there was probable cause to charge you with a crime, okay? Reasonable suspicion is the standard by which you can be detained and investigated. So, for instance, if a cop hears a scream and he comes over and there's like a woman who looks a little shaken up and there's a guy, the cop could argue that there is reasonable suspicion to stop you for a moment and just kind of like ask some questions and check around and see what's going on, right? But you can't be arrested. You can only be detained because of reasonable suspicion, all right? Probable cause is needed to make an arrest, all right? Now, because of due process, and it's a good thing and every country in the world does this, once you've been arrested, all right, if you've been arrested, you have a right to something called, I don't know if I'm using this word correctly, if there's a preferable term, or if I'm going to sound right. It's called an arraignment. An arraignment is where you're brought before a court and your charges are formally read to you, all right? I think in every state in the United States, I believe this process has to happen within 72 hours, okay? This type of thing, broadly speaking, I think is referred to as like habeas corpus, okay? You can issue a writ for habeas corpus if you need to say, hey, I want my charges read to me. I want to know why I'm being held. The reason why we do this is because you don't want a police officer to be able to arrest you and hold you indefinitely for absolutely no reason, okay? You want to have charges read to you. Charge me with a crime or let me the fuck out of here, okay? This is, broadly speaking, I think this whole process is kind of like referred to as like habeas corpus, I think. A writ of habeas corpus is issuing a writ saying, read me my charges or let me the fuck go, all right? And for charges you need probable cause. Okay. Trump authorized something called the Alien Enemies Act. And what was happening was people were being arrested, okay? An arrest was happening. And then those people were being deported out of the country with nothing happening. No due process, nothing, no charges read to them. They were just being spit out of the country. Okay. Now, obviously, 5 people came forward. At least 5 people are represented by lawyers that were successful in upgrading this to a class action thing, representing all, I think, Venezuelans in the United States, saying, hey, we're going to challenge these deportations. You can't deport these people. And the reason why we say that you can't deport these people is because of something called the APA, okay? This can't happen. You can't deport these people. And we're going to bring this deportation challenge under the APA, which is the Administrative Procedures Act, okay? They're going to say you didn't follow the proper procedures. You didn't actually determine that these people qualified as aliens, okay, or that they would be qualified in this statute, that they were part of some invading government or whatever. You don't even know if it applies to those people. So this act, okay, the way that you're doing this is not okay because you're violating these APA procedures. So we're going to challenge these actions in court to get you to stop doing this. All right. And in the meantime, we're asking for a temporary restraining order, which would lead into an injunction that basically says, we're so right here. The court's going to stop you from doing this because fuck you. This is crazy. OK. Temporary restraining orders to prevent irreparable harm that would be suffered before a court case goes through, where you're likely to succeed on the merits. And Judge Boasberg had granted this TRO. I believe this is just a ruling. Is this just a ruling on the TRO? On application to vacate the orders. OK, I believe this is just on the TRO, not the whole case. OK. Okay. Okay. So this is where we're at. Okay. So lawyers are representing Venezuelans saying you're deporting people in the U.S. and you need to stop because you're not following the Administrative Procedures Act. You're not following what's laid out in your law to determine if these people qualify for deportation. So we're going to a judge and we're not only are we filing this case, we're asking for a TRO, a temporary restraining order, to stop you from doing it. Okay. Now the government's response was, well, hold on. It kind of sounds like you're asking for people to have their charges read to them and then to either be released or charged with a crime. This sounds like a habeas claim, okay? Now, this might seem like an irrelevant distinction. However, there's an important little trick part here to a habeas claim. An Administrative Procedures Act, the appropriate venue for that is any federal court. Any federal court can hear an APA claim. So it was filed in the district court in D.C., in that district. But for a habeas claim, these are trickier. A habeas claim has to be filed in the federal court, not just in that venue, but in the particular court that's closest to the circumstances of the arrested person. So what that means is if this indeed has to be a habeas claim and not an APA challenge, that filing this in the DC circuit was inappropriate because it needed to be filed in a circuit court or in a district court in Texas or Arizona or New Mexico or whatever these people are being held. So that would mean it would get tossed. Now, the plaintiffs, the people representing the Venezuelans, they said, hold on, you're not even telling these people they're going to be deported, and we don't even know where the fuck you're holding them. We can't file writs for habeas corpus because you guys are detaining these people overnight. It's impossible to do this. So basically the government tried to make this argument. They're like, oh, you got to do it has to be a habeas writ that you're issuing here. It can't be an APA claim. That's not fair. And this was the back and forth. This was the meme game that was being played here. Now, Boasberg, we listened to the oral arguments, and then it was appealed up to the circuit court, which is your first court of federal appeals in D.C. When the judges were hearing this, they basically walked them through the thing and said that, like, well, obviously these habeas claims were impossible to follow through on because you guys were abducting people, basically, and deporting them before they could even notify a lawyer. And then the government basically just said, okay, well, sucks for them. These guys filed a lawsuit, even though these people, the five that they were being represented, like hadn't even, they weren't even under detention yet. They just filed it preemptively. And now it looks like what the Supreme Court has said, in the second time a TRO has been reviewed by the Supreme Court in as many weeks, which is wild. It sounds like the Supreme Court has said, we agree, this did need to be a habeas challenge. However, it sounds like the court has also said, that being said, you need to give notice to these people before you arrest and deport them, which hopefully the government follows through on, but who the fuck knows? Okay, that's my summary on this. What do you got, buddy?
I stepped off for a little bit, and you started talking about things that I could talk about. So Hobbit follower summoned me back. You've got the gist of it. I think that you're a little too strong on the Supreme Court saying that it should be a habeas claim, but for the gist of it, you've got it. As far as the order returning the man from El Salvador, were you talking about that right before I hopped on?
No, I think this was. Oh wait, is that what this one was about? I thought it was about. I thought it was about the entire challenge of that class action suit and the TRO that was issued.
Okay. So the reports that I read today, and I haven't gotten to read. I mean, the ruling is one page. There's no like.
Oh no! I saw that one page thing, but this is a different thing. I think this might have just come out like minutes ago. But I control F, and it looked like we had challenges to removal under the Alien Enemies Act, a statute which largely, quote, precludes judicial review, must be brought in habeas. And they used this argument, it sounds like, to vacate the temporary restraining order that had been issued by the district court and held by the circuit court.
Jesus Christ. All right. Well, sorry, I haven't seen that one yet.
They agree with that, the argument that their claims fall within the core of the writ of habeas corpus and thus must be brought in habeas. Yeah.
Well, it'll be an interesting one in the sense that, like, because they might say that there, but that doesn't technically like dismiss everything. I mean, one part of it is right now I'm still trying to find confirmation that the 5 people didn't get deported. The government said it multiple times, but I haven't seen anything saying where.
Well, my understanding is those 5 people were just 5 basically random people, and they just used those 5 people as a start to upgrade it to a class action. That those 5 people weren't necessarily people who had been deported.
Well, right, but then now they were saying, oh, it's a habeas claim, which the funny thing is that you could bring the habeas claim with the APA claim. That like it's so.
Well,
let's say
you
we
could,
went
but
back and
remember
did-
then the venue. Would you call it venue or jurisdiction? Like venue is just a different federal court.
Let's see. In this case,
Because remember
yeah,
that for the
technically
habeas claim, it has to be with
it's
the
jurisdiction.
Okay, yeah.
It's an issue of personal jurisdiction.
Yeah, the habeas claims have to be brought in the court nearest to where the people are actually being detained, which is what makes it more challenging, right?
It does, but in the sense that like the court, like it wouldn't be hard for these people at this point now that time has gone by. Presumably, the defense could figure out where these people are and file these claims.
Well, yeah, but the point is, you're thinking legally, okay? I'm thinking like movie.
I know.
It's not about a legal claim. It's about the fact that you could be a Venezuelan green card holder. ICE could show up at your house at 6 p.m., arrest you, take you to a detention center, and by noon the next day, you're deported. And you don't even have time to contact the lawyer, let alone file anything. And you can't file a preemptive habeas writ or whatever if you haven't even been detained. And I think that meme was what they were accusing them of doing, yeah. Or it's what they did do, right? Yeah.
I think you're right in the sense that what we're looking at now is they're saying, okay, it has to be a habeas claim. And as you say, well, the issue is that if your lawyer doesn't know where you are, or if you can't even get to a lawyer, right, and you don't have time to do these things, because if you have a visa, if you're an asylee, even if you're being deported as an undocumented immigrant, you have right to notice of those things happening so that you can contact an attorney. And, it's pretty I need to read it. I don't want to have a strong opinion without reading what you're discussing.
Sure.
But, it's pretty shocking to see the Supreme Court kind of just not even acknowledge that a due process issue is going on here. And also the other side of it is it's like, am I like, if I was a judge, am I more worried about someone's due process rights being violated, or am I more worried about the specific claim here with the habeas thing, right? Like, how offended am I by someone not filing a correct habeas petition versus someone having their due process rights taken away? Whenever we're looking at violations this large, it's really not that unusual for a judge to come out and be like, all right, like, these are extreme circumstances. Like, I had to sign a fucking TRO on a Saturday night. Like, obviously we are not dealing with the normal right now.
Yeah, well, that might be true.
Like, oh.
That might be true ordinarily, but you're thinking of a habeas claim that's filed ordinarily, like for a police arresting somebody. But we're talking about the president executing his fucking war powers. So now you do have huge competing interests where arguably the president's ability to act with war powers might supersede some individuals' due process rights in some circumstances, right?
But even if that's the case, where that's like we're framing it as, there's never been a time in which the Alien Enemies Act has been invoked where there was not some level of due process, right? Like if you go back and look at whenever it's been enacted before or whenever it's been executed before, the president laid out procedures for how it was to be used, right? Like there were procedures put in place for due process even under the previous uses of the Alien Enemy Act, and so it is a bit of a shock to the conscience, to use a legal term, to see this so extreme, and then now to see the Supreme Court follow it up. Like, I know I sound like some kind of like boob over here, being like, I'm shocked that the Supreme Court did this. I feel like when I say that, everyone's like, well, duh, obviously. But even still, it's very surprising. And the other side of it is they could have just said nothing. They could have said, we're not going to take this. The order stands. Y'all figure it out. There's no reason why the order could not have stood. There's been no showing.
Yeah.
There's no evidence.
And to reiterate, these are like TROs. This is the second temporary restraining order that has issued that the Supreme Court has reviewed. It's a pretty exceptional. I don't know if any TROs. It's just a very exceptional set of circumstances. And like, why can't preliminary injunctions are supposed to be heard pretty soon? We couldn't even wait for the injunction. Like why did the Supreme Court have to talk about this at all? Yeah, it's kind of weird, but whatever.
It's weird that we aren't at the preliminary injunction, because like literally if there's any kind of hearing discussing a TRO, it turns into a preliminary injunction. And like a because
definitionally TROs are ex parte. There's supposed to be one part. So the other party's going to argue against a TRO. A TRO is basically just a preliminary injunction before the preliminary injunction where only one side has been heard, right? So if you're going to start arguing about it, why just fucking do the preliminary injunction hearing? Like, why do all this bullshit to delay it even more? Just have the hearing of the preliminary injunction.
And also on top of all of that, every time this gets analyzed, everyone's analyzing it as a TRO or as a preliminary injunction, not a TRO. A TRO, you just have to show that, like, literally to get a TRO, like, you have to show the judge that you're going to be super fucking harmed if you don't get one. You don't even need to show merits and shit like that, because a case hasn't started. You just have to show either you're going to be so harmed that it's irreparable, or that the case couldn't be tried without it. That's it. And
well, I think
and
you
have
have
to just convince the judge.
You do have to show a likelihood to win on the merits for a TRO to be
Not
issued,
until
right?
you get to not until you get to a preliminary injunction hearing. A lot of judges continue to, they will analyze it with that step, and they will add that in the language preemptively before it. But technically, under the rules, a TRO, you only have to show imminent, like, irreparable harm, or that a case would become moot if it didn't show it. Because the other side of it is that if you do that, as soon as the TRO goes into effect, the other side can show up and respond. Right? If it's so bad, if the government had time to file an appeal, they had time to show up and argue their case. And if they didn't, and as you know, the appellate court said, they had the time in between to have that hearing, and at no point had they taken that step. Obviously, because they wanted to get in front of the Supreme Court so that the Supreme Court would do what it did, rather than, because even if they have to wait these days and go through the preliminary injunction appeal process like that, they don't get to say, well, this is extreme, right? Them taking extreme measures warrants remember the appeals court said, well, you guys are acting kind of extreme, so we are going to hear the appeal, right? And that kind of pushes it faster up the pipeline to the Supreme Court, and then the Supreme Court, acted incredibly shamefully here. This is I need to read it. I can't have stronger opinions than that. But sure. You're pretty spot on with this, and it's. I am worried that what I'm seeing here, and I think I told you this last time we talked, is that it feels like the Supreme Court, I don't feel like the Supreme Court here is giving away its powers, but I do feel like the Supreme Court is telling Trump, you're good, right? I think that I've yet to see the Supreme Court actually abdicate like any, or I should say, give up any of the powers that they have, like saying, because some people were hoping that the Supreme Court would say TROs can't affect non-parties, or TROs can't be this wide-reaching, or they can't. A lot of people were really wanting to see that, whether from the Congress or the Supreme Court. And from what you've told me, I don't see that here. But it does sound like, even though Roberts is playing footsie and Amy Coney Barrett, I guess, is finding her feet, I'm not sure, it doesn't seem like there's a serious roadblock at the SCOTUS. If there's anything that should offend them, it should be this. This is a gross, from every angle, but especially from a legal angle. If you understand the legal system, this should be offensive to you, and you should not ever want it to be upheld.
Yeah. What is this? Just so I can understand the writing, because I've read as many of these. When it says that you are, when you're joining parts 2 and 3B for dissenting, that means that Amy is a dissenting vote here, right? It's not like she just joins in part 2 and part 3B. This was a 5-4 decision, or?
Okay, can you link it to me so I can see what you're referring to? You're saying that, like, there's a section where she's dissenting on a specific part?
Yeah, I linked you the thing. It says down here, it just says, Justice Sotomayor, with whom Justice Kagan and Justice Jackson join, and with whom Justice Barrett joins as to parts 2 and 3B dissenting. So that means this was a 5-4 decision where she sided with the dissent, right? I believe that's what that means.
See. Yes.
Okay.
She joins with the part 2 and 3B of the dissent, but ultimately she would be voting against it. I believe. One second, let me just check one thing. Wow, they actually wrote something out for this. This is surprising.
She's joining in part, dissenting in part. Don't you ultimately have to cast a vote?
So her vote in this would be, I believe, they usually list it at the top. I believe it's technically saying that she will be considered voting for it, but dissenting to part of it. Since her vote isn't deciding it, then
maybe it doesn't matter. And it's a TRO anyway, so
it doesn't really matter. But she'll be considered, I believe, as though she is consenting. If they say, like, a decision came out, I believe they should say it as 6-3 rather than 5-4, even if she's dissenting on part of it. Though I need to see the significance of the dissent as well. Like, yeah,
sure.
I don't know. I think she and Robert are competing for the enlightened centrist position in the court right now, and neither are succeeding at actually showing any kind of restraint or any kind of, I don't know, being an adult in the room while these conservative judges act like children. but wow, this is. I was fully ready to come in here and have a spicy take about the guy that's in El Salvador, but this is just really disappointing.
Yeah. Well.
Okay. Anything else on this? I was just gonna hop in and chat with you real quick on it.
No, that's it. I haven't ready to. Apparently, BTC released a video on it, so I might listen to that. Although I don't know how the fuck he made a video about it already, unless my chat is confused and he made a video about there was a stay issued about the TRO, but it seems like now this is the decision they've made on it. My guess is any video that was made was probably about just the stay, and not the actual, not this overturning of it, but.
Yeah, okay, Jackson wrote stuff. Sorry, I'm just skimming this real quick.
There you go.
Well, yeah, this is. I guess I'll leave on this one. Is just that everybody should be upset about this. I think you pointed out in the past that this lack of due process that our judicial system's putting up with now means that no matter who you are, no matter what you look like, no matter what you've done, you can be named as a member of this Venezuelan gang and shipped off. And before you can tell your family, before you can tell your attorney, you'll never be seen again. And we've seen the government already say they can't get them back. And so guess what? You're just stuck doing hard labor. So I know that everybody's upset about the tariffs. I know everybody's upset about a bunch of things, but this is the greatest attack on the American government, people, just the concept of democracy here. This is terrifying.
So somebody in chat is saying, and I saw this cited before this was linked to me, there's a portion in the opinion that talks about how the detainees need to receive ample time to get notice that they are being deported. More specifically in this context, AEA detainees must receive... Yeah, but then why overturn this TRO? Why... And this part 3, I just started reading. In light of this agreement, the court's decision to intervene in this litigation is as inexplicable as it is dangerous. Why intervene at all?
Oh, this is really gross. So I just searched notice in here, and in the summary they discuss it lightly, and they probably discuss it more later on. It is well established that the Fifth Amendment entitles aliens to due process of law in the context of removal proceedings. So the detainees are entitled to notice and opportunity to be heard appropriate to the nature of the case. More specifically, in this context, AEA detainees must receive notice after the date of this order that they are subject to removal under the Act. So they're saying, oh yeah, you guys should have given them notice, and going forward, you need to give them notice. So they're saying, oh yeah, but then they're saying, oh, but they are doing that, so they have the opportunity to challenge the removal, and so they're saying, but that's not the question. They're saying that's not the question in front of us. They're saying you guys should. This is technically dicta. They're not actually making a ruling on this.
Yeah, they're just saying, like restating what the law says, but then they're also overturning the TRO at the same time.
Sure.
Yeah.
Threading the needle with a lawyer brain, you technically didn't ask us about notice here, so we're not going to make a ruling on notice. You asked us about whether or not this class of people is allowed to make an APA claim or if they have to make a habeas claim. And this dicta kind of supports the habeas thing, where it's like, oh, see, we do support them getting notice so that they can make the habeas claim. I agree with you. It doesn't make sense why they would uphold the TRO.
The problem is that the reason why that's so retarded, also, I fully reject the phrasing that you're using about this not being before the court. We have seen in recent American history, the court will gladly take up whatever issues it wants to. And the idea that they, for some weird principled reason, will never take up an issue that's not directly before it is utter horseshit. Okay, number one. Number two, I don't think that these people would have an issue doing habeas claims. The fact was that they literally fucking couldn't, which is like,
I'm a bit, there was no briefing here, and there was no real oral argument here, as far as I understand it, for the TROs. I need to do more research before I talk more about it, but I am a little bit disappointed that there are not more arguments about equity here, rather than law. And I think that the defendants, or I'm sorry, the plaintiffs, they should be making a lot of arguments in equity. And that means that they need to be saying, look, the issue here is that the actions that are going on are removing our ability to interact with the court system. We're not saying that we have the right. We're not saying that the law grants us things. We're saying that if we are to represent ourselves, if we are to show up in court, we need these things to happen, right? Like if for instance, if you move in some states, if you move for a continuance, there's no law that allows you to do that. You're just showing up in front of the court to make a motion in equity, right? And just saying, I would appreciate if we could do this because otherwise I can't show up. And I think that those arguments really need to be showing up more in the record. To be fair, I'm sure these people are doing the best they can and are probably much more intelligent than I am and know what they're doing. And it could just be that the judges are just ignoring any of those arguments and saying, I don't give a shit. We're just going to look at the law and who cares? But you're right to say that they couldn't do the habeas claim, and that should be a consideration in front of the court. They should say, look,
well, they say in the dissent, they have it in here, right? Against the backdrop of the U.S. government's unprecedented deportation of dozens of immigrants to a foreign prison without due process, a majority of this court sees fit to vacate the district court's order. The reason, apparently, is that the majority thinks plaintiffs' claims should have been styled as habeas actions and filed in the districts of their detention. In reaching that result, the majority flouts well-established limits on its jurisdiction, creates new law on the emergency docket, and elides the serious threat our intervention poses to the lives of the individual detainees. So it sounds like for the dissenting opinion here, right? They did consider like what are we actually talking about here? Like whose rights are being violated in such an egregious manner? Like Jesus,
right? And it's also I'm going to bet that the Supreme Court does very little to really examine the plea of the government here, saying, well, we have to do it because apparently there's some contingency of international negotiation with Venezuela or El Salvador on these specific people being detained, and the Supreme Court is happy to take that at face value, as though that bald lie is worth more than the due process rights of 200 people. It is, again, an incredibly shameful decision and one that shouldn't be here. I'll push back on you a little bit. Whenever you said that you reject the it's not in front of the court stuff. It is whenever you're dealing with judges, generally, they love to find reasons not to make decisions. That includes the Supreme Court. But they love to make decisions about things that they care about.
That they want to talk about,
yeah. You've spoken more than once about Thomas talking, opining about,
on whether or not a special counsel is constitutional.
Yeah. And so, and in this case, I think that the Supreme Court, I might be reading the tea leaves a little bit here, but I think they're saying, hey, we are going to give Trump what he wants, but we also want to keep our hands off it as much as possible, right? I think that is kind of a thing there where they're saying, oh, notice should be afforded, but we're not going to make a decision, is enough for them to wash their hands and say, look, we are upholding due process. We believe in notice, blah, blah, blah. Mm-hmm. But we're still going to give them what they want. I think this is they're trying to get their cake and eat it too, and I think ultimately that's no better than if they said nothing at all. But also, I think if they had, I think that the only way that they could really bring notice in to talk about it is if they say that the habeas claims are allowed, or that they need to be habeas claims. And then on top of that, they need to have had notice. But then I think the issue here is we're already past that stage, right? Yeah. They're saying, okay, the notice didn't happen. The TRO technically doesn't solve that problem. It's just you're right. It's bullshit. You're right. It's bullshit. But it is a thing where, like, if they go down that kind of like avenue, there's really not a lot they can do other than to just reach down into the lower courts and kind of do it themselves, which they hate.
Well, they very easily. This is a TRO. There was five more days left on it. If they're saying the government has to do this anyway, and they need to make sure they do this, they literally could have just had the TRO stand, and then that's it. They didn't have to hear this. They didn't have to write anything about this at all. No.
I agree with you on that. They should have. I think the right move would have been to do that. Writing this opinion, I don't know how you write this opinion. The way they did, where they just kind of barely touched on the notice thing and left. Mm-hmm. Them saying trying to enforce the notice thing while doing the habeas thing. It's just like asking these people not to be monsters.
Also, I don't know. I'm curious because I don't actually know the difference between. I don't know. I don't have huge history in habeas and APA. Would this even be it? The Supreme Court is saying here, and the government argued it. But is it actually a habeas claim? If the AEA applies to you, do you even have a habeas claim there? Can't they just deport you, assuming that you're part of that category of person? Do you even get a right there at all, or?
I mean, there's a detainment to remove you. There must be detainment, and if you are detained, you have the right to a habeas claim, right? So there is a possibility of the habeas claim being in there. I think that the plaintiffs have made a very compelling argument that they are not contesting their habeas claim.
The reason why I'm asking this is because let's say they check your ID and they go, oh, this is a Venezuelan person, so he does fall under the AEA proclamation here. Does that person have any rights at that point to like a due process if they've made that determination?
Yeah, that's
okay.
what.
All right. I haven't read the Alien Enemies Act, so yeah, okay.
Yeah, but to be clear though, in the past, all of those were policies set up by the executive when they invoked it.
Sure.
And the Supreme Court has said the only part of the habeas claim is to make sure that you got your notice and they confirmed that you are an alien enemy. And you fall within whatever description the government gave for an alien enemy. Though that's it. That's what you get. And so you do have those for your detainment, but not the removal. The APA is for removal, not for detainment. And I think that that's a compelling argument for why it's not a habeas claim, because the other side of it is the government has made multiple public statements that these people being arrested are being arrested under multiple laws. So they're saying, hey, look, we're not even contesting that you could arrest us because we've obviously broken some laws according to you, and we're not even going to contest that right now. We're just contesting the removal part.
Oh yeah, okay, yeah. That's what I was wondering. Like, why it doesn't seem like an ordinary habeas claim here. So I don't know. Because like if I'm making a habeas claim, I'm saying you need to read me charges, or you have to let me the fuck go. This is bullshit. But it doesn't sound like these people are even necessarily doing that. They're fighting a deportation thing, but I mean, I don't know the deals, all that. So yeah, okay.
Yeah, and I think I don't know. I need to read this before. I'm actually speaking pretty out of turn. I need to read this. I keep saying that. But one thing on to think about too is like a lot of times courts will look at the remedies and try to say they don't want to put out remedies that have no purpose and can't be followed. And so that was kind of where I was coming in on. I was going to come in on the guy where they said you got to get him back from El Salvador. Mm-hmm. As much as I agree that they need to get him back and things like that, the court ordering the U.S. government to do that isn't really a thing that is a real remedy. We're in damages situation right now. Unfortunately, that's what happens because he's outside the jurisdiction. There's not like a clear path to get there.
You undermine the integrity of your own court, though, if you're issuing requirements that literally can never be followed through on, right? Sure.
Right, and so that's kind of where like I'm kind of coming in on this notice issue with the TRO. It's like, well, that's already fucked, and you already have these guys in here. Mm-hmm. But I think that I do have to agree with you though, because the TRO is literally, all it does is make it where you can't deport them. And so the Supreme Court is saying you have people in court with issues, and we're going to say it's okay for you to deport them now, which is just a really weird thing for again, it's just like, the more I talk about it out loud, the worse it's getting, because it doesn't make any sense why they would lay this down. Fuck me, man. Well, I'll read this, and if there's anything more to talk about it, I'll hop back on at some point.
All right. Well, have fun. Be careful.
You too.
This is Democracy Watch. Mark, all eyes right now are on the Supreme Court, which has weighed in on this question as to whether the Trump administration has to return this wrongfully accused migrant who was sent over to El Salvador of being sent back. There was a deadline that was imposed today, April 7th at 11:59 p.m. The Supreme Court has weighed in. Can you explain what just happened?
Yeah, so as you point out, this individual was subject to an order not to have him removed to El Salvador. And what the federal government then did was remove him to El Salvador, right? They sent him to El Salvador in violation of the immigration judge's prior order. There was a lawsuit, and the federal judge who hears this basically says the government has to go and have him returned by midnight tonight, 11:59 tonight. The government then appealed to the U.S. Supreme Court, and Chief Justice Roberts has put in place a temporary stay. In other words, blocking that midnight order, that order to have him returned by midnight tonight, that has been blocked while this case is now briefed and decided by the Supreme Court.
Well, look, I know the reaction to this has been folks are pretty upset about the fact that you have somebody who this administration had already conceded was there due to an administrative error. So already the notion that we can just disappear somebody, really because of no other reason than the color of his skin at this point, to a foreign country is bad enough unto itself. But why wouldn't the response from the Supreme Court just to be like, this was clearly in error, and so yes, of course you should bring him back immediately. Why stay this decision?
Okay, so look, I am far from an apologist.
Oh, fuck. So this is just about the stay, meaning preventing the TRO from standing, but this isn't about, it doesn't sound like this is about the the longer ruling that was just released.
Supreme Court. And I'm not predicting, by the way, that they are going to do the right thing. I think in the most charitable light, whether they deserve that or not is another question that you and I can discuss. But in the most charitable light, what the Chief Justice would say is, look, we just got a motion from the government, and we need to have a day or two to consider this motion to see whether the federal government has a point here or doesn't have a point here.
That's what I thought, because it sounded like they had until tomorrow, but they just...
And so in order to have the time for us to receive briefing and to make a decision, we need to just put a pause on things. And in fairness to the Chief Justice, he did order the opposition to the government's motion,
to file
this individual's lawyer, to file their brief tomorrow.
But it sounds like, but it doesn't matter. They issued a decision anyway. So unless this is another thing that's being talked about or something I'm missing, but...
So I think he is envisioning a relatively quick turnaround for the Supreme Court to decide the case. So that's the purpose of administrative stay, is essentially to say, look, we're not judging which side's right. We're just giving the Supreme Court enough time to consider it. And that's I think what I think the court's answer would be. Now, again, that is not saying that the Supreme Court is going to get to the right decision. I have deep concerns that it will not.
In your experience, to that exact point, does the Supreme Court's decision to stay a ruling, at least while they're considering more of these details, does that signal anything? Does that offer us anything that we can glean from the tea leaves in terms of how they'll eventually rule? Or are they completely separate and apart?
They're really separate and apart. I mean, the Chief Justice issued this stay without really a vote of his colleagues, so he probably doesn't even know what his colleagues think. This is a...
I bet he knows what some of his colleagues think.
Okay, fair enough. He knows what some of his colleagues think. The only tea leaves that ever get read into these are how quickly the case is then briefed and decided. The government sought some expedited treatment of some of their cases and frankly failed to get them. In this instance, they are very much getting expedited consideration. Like I said, the motion went in and has already led to an administrative stay. The briefing will be concluded by tomorrow. So, I think the Chief Justice is anticipating that we're going to have an outcome from the U.S. Supreme Court relatively quickly. But I wouldn't overread the fact that there's an administrative stay because, like I said, if there wasn't an administrative stay, the argument goes, then the government would never get a chance to plead its case to the Supreme Court because the order would have required the person to be removed. Now, again, I'm not sure I entirely buy that because, of course, they could bring him back, and then if they won the case, they could send him back out again or something. But that is at least what the theory I think that the Supreme Court's operating under.
You mentioned before that you have some concerns in terms of, even after the Supreme Court properly hears this case, some concerns about how they might rule. Why do you say that?
Yeah, I'm worried, and I think about it this way, Brian. And you and I have talked about some of this before in the context of other cases we've talked about. There are 5 justices or more on the Supreme Court to uphold a very, very strong executive, very, very strong presidential powers, and that would portend poorly here. Now, there are also almost certainly 5 votes in some circumstances to defend the role of the judiciary to issue binding orders. So it's, there's a little bit of a tug of war here, right? Like beyond the so-called merits here, whether he was or was not a member of a gang and whether or not he should or shouldn't have been, whatever, there is a fundamental tension here between the fact that the executive branch disregarded an administrative judge's order. Now, they can say it was done as an administrative error. That really doesn't matter, right? At the end of the day, there was an order not to remove him to El Salvador, and he was, in fact, removed to El Salvador. So the administration has acknowledged, although, like I said, they minimize it and put it in the category of administrative error, which is like, by the way, a little rich. I mean, administrative error is usually like, they misplaced a form for a day.
Not misplaced a human being, but yes.
They sent someone to
a foreign gulag?
Yeah. But that's on one side. On the other hand, you will have some Supreme Court justices who are going to argue, look, this is a El Salvadorian citizen who's in the United States, who, the government has grave doubts about, who has been sent to El Salvador. And, why is that? Like, what is the power of the court to tell the U.S. government to go now get back from El Salvador one of its own citizens? And I think that those are going to be I don't think it was a citizen tensions before you get, like I said, even to the merits of whether he was right or wrongly targeted or right or wrongly designated as a gang member. And I worry that at least on this Supreme Court, they are going to want to throw up their arms and say, we can't order presidents to retrieve people from foreign countries, especially when they're not U.S. citizens. And that will do damage. That will do damage not only to this individual, obviously, and his family, not only to the sort of rule of law, but it will do real damage, I think, to the ability of anyone to feel like they can rely on court orders. Because in some respects, now this was an immigration judge, not an Article 3 court, but still, it was a judge who issued this ban, and it has been violated. And at some point, if the courts are not going to stand up for the enforcement of judicial orders, then we're going to wind up in a world in which you'll have, I suspect, the Trump administration being given an inch, taking a mile, and then saying, oh, wait, a mile is too far for us to walk back.
Is there any concern, Mark, that if the Supreme Court opts to side with the Trump team, this is a case regarding the Trump administration effectively disappearing somebody with no due process, and that in and of itself is antithetical to the Constitution because anybody who's here has constitutional protections, and yet he wasn't afforded those. So if the Supreme Court goes ahead and says, no, it's okay, he can stay there, we're going to side with the Trump team, isn't that also them de facto saying that the whole concept of due process, the whole concept of constitutional protections for those who are not American citizens just vanishes?
Yeah, I wouldn't necessarily add for non-American citizens because, as you point out, you have due process rights by being present in the United States. Now, they may be different due process rights if you're a citizen versus non-citizen, but you have the Constitution applies to people in the United States. Right. And Brian, in some ways, it's even worse than you laid out because, I would argue this individual, this guy, did get due process and was given the protection of an order. Like it wasn't that he didn't have any due process. He had due process and essentially won the right not to be sent back to El Salvador. And yet they did that anyway. So it's like there wasn't due process to not follow the immigration judge's order, which is in some ways worse than there having been no process at all.
Now we're effectively just in constitutional crisis territory. Instead of just eliminating one provision of the Constitution, now you're just saying the Constitution doesn't apply anymore.
That's what makes this particular case, I think, so much more troubling. I think if this person had been, in immigration detention and had just been put on a plane and sent to El Salvador, and an immigration judge had never heard the case, then he would look a lot like the Venezuelans who have been sent to the same prison, except he would be El Salvadorian. And there you're fighting exactly as you say over whether they get due process or didn't get due process. Here, an immigration judge actually said, "Don't do this thing," and then the government did it and said it was an administrative error, which is just like boy. I mean, I'm not sure that I accept that it couldn't be. It may have been an error. I mean, it was an error, but it may have been even something they didn't intend to violate the court's order. But it was hardly just an administrative error. I mean, it wasn't like he was put in cell A versus cell B, or he was brought to the wrong courthouse for it. I mean, he was literally sent to this gulag of a prison in El Salvador. And so, yeah, that's why I say I think that this is going to be a hard call for some of the justices on the Supreme Court, because on the one hand, they will be sympathetic to the executive branch being able to run foreign policy and being able to run immigration. On the other hand, they've got to weigh the fact that if they let that happen here, they have effectively just allowed the administration to blow through the order that was in place here. And that, I think, becomes incredibly dangerous because, Brian, there are lots of legal constraints on what the administration can do. I mean, the administration can't, for example, send a U.S. citizen to El Salvador. But the president of the United States mused over the weekend that maybe he can. Maybe he'd like to see that, or maybe that's an option. And, it would be a hell of a thing if we were sitting here and said, well, they sent an American citizen there, and the U.S. government's position was, oops, that was an administrative oversight.
Right. And finally, Mark, let's finish off with this, because, the DOJ did argue this in court, and there were lawyers who deigned to be honest about what was happening in court, and the DOJ has since removed those attorneys, removed those prosecutors from the DOJ. Can I have your reaction to that?
Yeah, so look, I've had a more mixed reaction here than I think a lot of people on the left have. I think a lot of people on the left, they immediately see these DOJ lawyers as sort of heroes, right? They admitted the thing that, that this was an error and that this was a mistake, and then they were removed, and they are the victims of Donald Trump. And I don't disagree with that in the main. But you and I have had this conversation now in across a bunch of cases, including the Eric Adams case and that. I mean, these DOJ lawyers were standing up in a courtroom defending the Department of Justice's removal of this individual, right? They got in trouble essentially for acknowledging it was an administrative error, right? Not for the fact that they didn't stand up in this position. So I do think, Brian, we are at a point where there is this open question about what are we to expect of government lawyers. I expect that government lawyers won't take on cases and will risk their jobs to not argue for immoral or illegal things. That is where I draw the line. But there are lots of people who are drawing the line slightly differently. They're saying, look, if you'd rather have better, more ethical lawyers than less ethical and worse people. And so, if you have people who can walk that balance and still maintain some level of credibility, that's better. I don't know, Brian, which one the right answer is. In this case, it is certainly the case that these lawyers did admit something to the court that was very helpful to the individuals been detained and their family, and they have been removed. And it's interesting that the Fourth Circuit that issued an opinion in this case after the Supreme Court got the case, which is procedurally weird unto itself. But even there, some of the conservative judges on the court indicated that these lawyers had been removed for essentially being candid with the court, which is actually their job.
Right, and we couldn't possibly have that. Well, look, I think all of this underscores the need for folks who are going to act with integrity, who are going to fight the worst excesses of this administration. That's what you and your team have been doing relentlessly since the very beginning, since Trump took office. So for everybody watching right now, one small step that we can all take to show some appreciation, show some support for the work that Mark and his team are doing is to sign up for Democracy Docket, which is the news outlet he founded to focus on everything voting and elections.
Democracy Docket.
I'll put the link right here on the screen and also in the post description of this video. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.
Wow. That's wild, chat.
What do you think about the vandalism?
Amber thinks Asmus enlightens interest. No, I just think that he's pro common sense and pro looking at all the sides and thinking for yourself, which is good. Do I think he's enlightened? Absolutely not. He doesn't leave his house enough to have gone on an enlightenment journey. Okay, he merely watches and has thoughts, which is more than I can say for most, streamers willing to watch the news. A lot of them watch it and pick a side that appeals to their image and branding and don't actually tell us what they really think or choose to think anything, really, I guess.
Damn. I don't know why, but we got Amaranth's political takes now. Thank you for that.
I'm at the protest right now in New York City.
I can't handle this asthma slap right now. We didn't even finish this video. It's gonna be dumb. I can already.
Do I personally think Mel Gibson should be able to get his right to own firearms back? Oh, reluctantly, yes. And here's why. Mel Gibson was married to his first wife for eons, for a very long time, and there were no accounts of him being abusive. Then he was with this woman for a year, and this happened. I do personally think this woman gaslit and antagonized him. I do. Also, I think she took advantage of the vulnerable state he was in, especially as he was dealing with alcoholism and personal demons and the fact that his career was tanking or whatever the case may have you. Either way, none of that justifies his actions. Let me be clear. You ask me, I'd have given him the same charge. He all but admitted to putting his hands on her to some degree. So yeah, he deserved to be charged, but to what degree? That's harder to say. Because when I looked into the case and I tried to gather as much as I could, it starts to look like one of those chaotic, emotionally charged situations where both parties were acting out. There were claims that she was holding their baby, being hysterical, and he slapped her just to kind of bring her back to reality. Then she made accusations that he punched her in the stomach and knocked her teeth out and did some bunch of other shit. Now look, you shouldn't put your hands on a woman or a man unless it's in self-defense, period. But if what he said he did is what he did, I don't necessarily think that particular act rises to the level of, say, felony domestic violence where someone is full-on wailing on a partner or punching them with a closed fist. There are levels to this. One type of abuse demonstrates a pattern of behavior so egregious that we simply can't trust you with a firearm. Another type, it may still be wrong, it may still be criminal, but it's more of a momentary lapse. If enough time passes and you demonstrate rehabilitation, we have to be open to the idea of redemption. That doesn't mean it wasn't wrong. That doesn't mean it didn't deserve consequences. It means we understand people make mistakes and we look at the context, the aftermath, and the behavior since. And in all fairness, because like I said, I don't have any personal interest in defending Mel Gibson. He could have changed from the racial standpoint. I don't know, he maybe...
All of this analysis is fucking retarded. I think you can just say, I don't know why you permanently lose your right to own a firearm based on anything. That seems kind of weird to me. Like, I'd be okay with tossing that law, but I don't know why we need to analyze the individual case and all this bullshit.
Didn't change and he stayed the same. I don't know. I don't really care. But legally, and even to a degree logically, there's room here for the idea of restoration. Because again, there are levels to abuse. All of it should be punished, but not all of it is equal. And if someone can demonstrate with a level of certainty that they don't have a pattern of violence and have truly made a change, then yeah, I think we can consider restoring their rights. How long that should take, I don't know. But in Mel's case, it's been 14 years. He's remarried. There haven't been any public incidents or reports of further abuse, and clearly he hasn't repeated this behavior. So yeah, if we're going to have a system for restoring rights, Mel Gibson should be on that list. Let me make another thing clear too. I don't think it should just be Mel Gibson or those 10 people. I think everyone who is in the same type of position should be afforded this opportunity. I don't think abuse is ever justified. Physical, emotionally, or verbally, none of it. Not from a man to a woman, not from a woman to a man. The only justification for putting hands on someone is self-defense. That's it. Up, down, left, right, doesn't matter who it is. If it's not self-defense, it's wrong, period. Now, sure, there are levels, but that doesn't make it right. And look, people need to be really careful about how quick they are to say someone with a domestic...
Okay. Quick meme search. I'm just curious.
As there is breaking news at this hour.
Oh, would you look at that? They found him guilty.
A guilty verdict in Hunter Biden's federal gun trial in Wilmington, Delaware. The president's son facing 3 felony counts, accused of lying in a federal form about drug use when he bought a gun in 2018, saying he was not a drug user, and prosecutors arguing he illegally had that gun for 11 days. After deliberating for about an hour on the first day, about 2 hours today, they have found him guilty on all 3 charges. Count 1, making a false statement in the purchase of a firearm. Guilty of count 2, making a false statement related to information required to be kept by a federal licensed firearms dealer. And guilty on count 3, possessing a firearm by a person who is an unlawful user or addicted to a controlled substance. So again, the breaking news at this hour, Hunter Biden found guilty on all 3 felony charges.
Each of these counts required the jurors to take into account what Hunter's defense was here, which is basically that while he had abused drugs, as he confessed in his memoir, Beautiful Things, as the jurors heard plenty of evidence about, at that time Hunter Biden said, he didn't testify, but his lawyer presented evidence that he did not feel that he was actually abusing drugs at that time and therefore was not guilty of these crimes.
As we know, the First Lady, Jill Biden, they're supporting her son every day but one in this trial.
I'm honestly surprised.
Multiple members of the family and friends close to Hunter Biden all there.
I'm honestly surprised, really surprised. I figured they would just sweep this under the rug and find him innocent, and I'd be here with a video screaming bloody murder. Not because I really think he should be in jail, but because it would demonstrate a massive amount of hypocrisy from the people on the anti-gun side. But I have mixed feelings about this verdict. As a lawyer, he clearly broke the law, but it's the question he lied about that bugs me. The federal...
Oh, okay. Maybe he's at least consistent on this. This conviction was fucking retarded. And 4473's questions about whether or not you're an unlawful user or addicted to a narcotic is fucking retarded. That's good, at least.
Form you fill out when you buy a gun is called a 4473. And if you're caught lying about any of the questions on this form, they'll Hunter Biden you. When Hunter Biden filled out this form, he put no on the question that asked him, are you an unlawful user or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? I don't even think this question should even be on a 4473. And it's mainly due to the green. On the federal level, Mary Jane is a controlled substance. I personally don't like the green. I hate it, actually. I hate it a lot. But I don't think it should be a controlled substance, nor do I think the use of it should preclude you from buying a gun if you're not currently under the influence when you go to buy the gun. I can be addicted to alcohol and go buy a car all day day long as I'm not drunk when I buy it or drive it. I think it should be treated like cigarettes. And it is more or less in some states like California. But if you live in one of these states where it is legal and you do it from time to time and you put no on that question, you're breaking federal law. If you put yes, you can't buy a gun. So you're stuck deciding between breaking the law or not being able to buy a gun. You see what I'm getting at? It's kind of goofy. Yes, I genuinely hate the green. But can we stop acting like it's some type of evil drug that's killing a bunch of people? Because it's not. That said, Hunter Biden was doing something a lot harder than the green. And I'm not here to defend the use of that. I was born in the 80s, so I saw the residual effects of what that substance had on that era. And it wasn't pretty. Suffice it to say, I think the 4473 is actually dumb. Just run the background check and call it a day. It's just a soft-core national gun registry anyway.
Trump's manly tariffs. Pundit believes it could reverse crisis in masculinity. Absolutely fucking true and based. Can't you could turn off public chat in PoE, right? Can't you turn it off? Crazy that he was one of the top ranked ladder players in the world, but he doesn't know how to control his public chat, huh?
Oh, lost connection. Connection lost.
He died in the tutorial. Oh, rip. Why? What happened to Vivek Ramaswamy? True, where'd that guy go? Remember he was supposed to be the co-owner or whatever of Doge? Come
on, you work so hard. You're so close.
Wait, I want a video.
You're so, oh, the other way. You gotta, I think I gotta do it again. There you go.
Oh no.
You can do it. You'll get it.
You've been doing a lot of arm work at the gym, right?
He even brought his signed tearing gloves.
You've worked so hard. We've done it together. Come on, we're bonded now. Under your pillow.
Jesus.
Oh, come on.
Oh no.
Come on, rip it. Come on, rip it.
The Iranian taxi driver was saying he was a fan of Israel. Nice. To Hassan. Opinion. It's impossible to convert your MAGA parents because they're retarded. Jesus. Yeah, that's what they meant about manly tariffs. We need to help these men. True. There's no way this military parade thing is going to happen. I don't believe it, but we'll see.
North Korea is one of the poor.
Did you see The Brutalist? Nope. Unless you're talking about something your mom.
The market immediately crashed after the
Hassett. Trump is considering a Tony Hawk style kickflip with the markets. May drop into the bowl as soon as 10:45 EST. Jesus. Damn! Dying in 4, 3, 2, 1. Fuck. Well, he doesn't even die. Why are we posting Forsen clips where he's not even dying at the end? What the fuck? What? Jesus. He's the god gamer, that's why. Yeah, true. Okay, stay mad. I'm going home early today. Leaving the office. Oh yeah, go watch my George Santos show. Here you go. Oh, that's 2 years old. Soy face. Yeah, I don't get overtime until Trump's taking the tax away from it. Be careful, don't die.